Good morning, everyone. I'm very happy to be here and to be able to share with you a few operational insights from the Working Party 29 on the way we are preparing for the ODPB and for the GDPR. As you imagine, we're very busy because, in fact, we have two main objectives. First is to assist the controllers and the processors to understand the new rules and to implement them. But we have another objective that is more an internal objective, that is to be organized in between us and to have the proper relationship and procedures to be able to implement the GDPR. So it's quite of a busy time, and as I think it's Elizabeth Denham who was saying this, she said it's like changing a wheel on a moving car, and it's exactly true because we still have to implement the directive. So it's quite of a tough period, and but I will come to that after. So the guidelines. Mm-hmm. You want me to discuss and to say a little bit about the guidelines. What I can say to start with is that, of course, at the Working Party 29 level, we are very conscious that the GDPR is a huge change for controllers and processors. Even if the principles of the directive are not changing, the implementation, the tools of these principles are totally different. And of course, it implies for the controllers and the processors huge investment in terms of IT, in terms of human resources, in terms of organization. So in such a context, our main purpose is to make sure the key rules are simple and understood. And to be honest, with the GDPR, it's not so easy, because these are complex rules. So it is why the Working Party 29 decided to adopt two action plans in which we identify some key subjects on which we want harmonization and simplification to be at their best, because we believed that on these key subjects we need to be clearly, the rules need to be clearly understood and implemented. And this is the reason of the guidelines. Through these guidelines, we've chosen several subjects on which we are pursuing these two objectives of simplification and harmonization. So we already have adopted three guidelines on DPO, data portability, and lead authority. And we are in the process of finalizing the adoption of the guidelines for DPA. And we still have, as you said, a few other guidelines in the pipe. I'm not going to comment each of these guidelines. I just want to point several substantial points and also some methodology points related to these guidelines. First, on the DPO. On the DPO, the main question is, do I have to designate a DPO? So the guidelines tries to clarify the conditions under which you have to designate a DPO. And besides this clarification, the guideline take position on several delicate issues, like if it's not an obligation to have a DPO, if I voluntarily decide to have a DPO, what is the status of this DPO? And the answer of the Working Party 29 is, of course, that all the provisions of the GDPR applies once the DPO, as an official DPO, even if it's on a voluntary basis, it's designated. Another tricky question is, should the DPO be personally responsible in case of a non-compliance with the GDPR? And the answer of the Working Party 29 is, of course, she cannot or he cannot be penalized for exercising his or her activities as DPO unless he is, of course, betraying an obligation, a specific obligation he has as a DPO. Why did we choose the DPO as one of our first guidelines? We chose the DPO as our first guideline because we strongly believe this function that is new is a key function for the implementation of the GDPR, because this DPO will be in charge of piloting all the compliance efforts of the company interested. And in fact, this DPO has to be, in our mind, very close to the operational activities, to diffuse in these operational activities the privacy culture, but also very close to the executive, I would say, board, in order to be able to have a strategic influence within the company belongs to. So it is why, because this function is so important, that we chose to have DPO guideline as a priority. Second guideline, data portability. Data portability is probably one of the main innovations of the GDPR. It's a new right given to the individual. And of course, the main question was to define precisely the scope of these rights. And to be clear with you, we had very active conversation with business representatives, with the Commission, on the way we had to understand the scope of these rights. And the position that we took is a rather large, I would say, interpretation of these rights in order to give substance to it and to have in mind also the very high social expectation of ownership and of possibility to master its own data expressed from the consumers and the citizens after, the Snowden disclosure. There is a very high social expectation on the possibility to be more active as an individual on its own data, and the portability right answer to this social demand. So we believed it was our duty to understand these rights in a rather extensive manner without, I think, putting prejudice to the secrets of the company and the value added developed by a company on the data. Third guidelines on the lead authority. Lead authority is also very important in the GDPR because, in fact, the lead authority will be the place with which all the European company, transborder company will be talking to. It will be the entity responsible to handle complaints and investigation, and of course it will cooperate with all the concerned authorities in other member states. The question is, where is the lead authority? And there were several observers saying that it was very simple to determine the lead authority because it was the authority of the headquarters. And we had to explain in the guidelines that it was a bit more delicate as regard the writing of the GDPR. And the position that the Working Party took is that the designation of the lead, and in fact it is exactly what the text itself says, is related to the analysis of the treatment themselves and not to a preset organization of the company, even if there is, of course, a high probability that the central administration of a company will be the place of the lead because it will concentrate, naturally, the main responsibilities and means of the treatments concerned. So this is important because for the companies, of course, it has, I would say, organizational consequences. Apart from the designation of the lead, the question of the lead authority is also the question of the type of cooperation this lead will develop with the other national supervisory authorities potentially competent. As you know, in the text, the lead doesn't have a kind of monopoly of the regulation. The lead has, in some cases, to share the regulation power with other concerned authorities. And it is a very complex mechanism. And we are right now in the process of getting organized to specify and to precise all the relationship we're going to have as a lead or as a concerned authorities. I can't give you the final results. What I can tell you is the way, as chair of the Working Party 29, I would like to reflect on this very delicate question. And I would say I would try to have three basic principles. First is to trust national DPA and to rely on them. The regulation power starts from the national DPA, so it has to be respected and relied on. Second principle, try to let the local cases be handled at the national level if there is no real value added through the consistency. In other words, and while respecting the rules of the GDPR, trying to let the case at the national level if there is no real reason to go upwards at the consistency level. And third principle, if the consistency level has to be activated, and so if the lead has to work with other concerned DPAs, then full cooperation and exchanges of information between the lead and the concerned authorities. I'm not sure that we're going to be able to work on these three, I would say, good sense principles, but we will try in the following month in order to keep the balance between the national level of DPAs and the European level of the ODPB. These are the few comments I could make on the first guidelines. I want to say something beyond substance on methodology, because the methodology that we used to produce these guidelines is quite important. We decided to consult beforehand and afterhand with our stakeholders, civil society and business representatives. You know that we organized already two Fab Labs to collect the expectations and the questions from these actors. And also, once we had elaborated the guidelines, the project guidelines, we put these projects under consultation before final adoption. Why have we done this? It's not only to communicate properly. It is because we strongly believe that we are entering into a new type of relationship between regulators and actors. In the digital environment, regulation cannot be graved into the stone forever. It has to be flexible and in line with the realities of the ground. Moreover, the public authorities, as we are, do not have all the clues to solve a question, and they need to build on private actors' initiative and expertise. For these reasons, regulators need to be open to the discussion and very close to the ground. Of course, our consultation process can be improved. There had been critics on the Fab Labs, on the fact that not everyone was invited, that the consultation process was too short. All of this is true. It was a sort of testing experiment, and we can, of course, better the process, and we are open to any suggestions on this matter. But whatever the process, I want really to stress the idea that the actors, business representatives, civil society, must understand that the consultation doesn't mean that we will always agree. At some point, the regulator takes its responsibility and decide on the interpretation of the rules that he wants to choose. For instance, this is what we've done through the portability right, and this was clearly the purpose of the guidelines. Apart from these three first guidelines, we will have other guidelines on consent, profiling, data breach notification, certification and transparency. And we will probably organize another Fab Lab before the end of the year. And most of these guidelines will be ready by December. So you imagine that it's a huge work related to these guidelines. These guidelines could be reviewed in the following years. As I said, they belong to flexible regulation tools. So they are adopted, but they are also, it's possible for us to review the guidelines within 2 or 3 years. But I don't think we will go beyond the initial list. And I want to say at this stage of the conversation something very simple, because in our debate we are always, as DPA, hassled by questions from the floor and from the business representative on the question, we won't be ready. You know, some people say, oh, well, we won't be ready in 2018, so what's going to happen? I want to say that the guidelines, of course, are a guidance to help you comply, but I want also to tell that even if there is a big change in the regulation in 2018, and if you have to adapt to this big change, the May 2018 won't sound as a sort of a hammer blow, you know. Everything won't be automatically illegal from May 2018. In fact, I think we're more in a situation of having a kind of collective learning curve between the industry representative and between the regulators, and we will go up the learning curve together. So it's important to say this, because unless people are getting to be very anxious. Now, this was the guidelines for the controllers and processors, but as I said at the beginning, there is also a huge change for us, because as you know, the Working Party 29 will evolve into an ODPB, a new European institution called the ODPB. And as the Working Party 29 doesn't have any legal personality and is more of an expert group, the ODPB will have a moral personality and will have also a binding power, because it will be empowered to arbitrate dispute between national authorities and also to develop a European doctrine. I think the innovation of the ODPB is very important, not only because the ODPB will have the binding power, and actually it will be the only subject in European law in which you have the possibility for 28 national regulators to co-decide on a common case. There is no other example. So even this is very innovative. But I think the innovation goes beyond. It goes to the idea that we are about to set a new governance architecture for privacy protection, which combines both decentralization at the national level. As I said, the first actors of compliance and of regulation are the national DPAs that are going to be stronger, but also integration at the European level when it's needed, with the ODPB co-deciding on trans-border cases. In fact, we're going to produce a governance model with 3 layers: national layers with DPA, then bilateral or multilateral cooperation between the supervisory authorities, and if they don't agree, and only if they don't agree, ODPB. So you have to understand that the ODPB will be in the future more a head of a network, a kind of community manager, arbitrating conflicts between supervisory authorities and bringing common solutions when these are needed. And I believe it's a huge innovation, and it is a unique opportunity that we have to bring a new culture in European institutions and also maybe to revamp, I would say, their image. At the Working Party 29, we are fully conscious of the importance of this mutation from to the ODPB, and we are working very hard with the ODPS that is going to provide the Secretariat of the ODPB to establish the new processes and rules that will govern this new body. We are working on the budget, on the recruitment process, on the MOU that will be signed between the ODPB and its secretariat. We're working on the website, on the logo, so everything is very operational, but it has to be operational because it is the back office of the ODPB. And so if we want this new system to function, we need to have a proper and running back office. I can describe a little bit more, but I think maybe it's a little bit too early and we are running out of time. So I think I'm almost finished. As you can see, the effort that we have to develop to be prepared for the ODPB and to transform the Working Party 29 into the ODPB are huge. When I was preparing for this session, I was trying to count how many working blocks do we have in order for the towards the controllers or towards the supervisory authorities. We need to be finished. I think we have more than 15 working fields to be completed in order to be totally ready for May 2018. I guess we will be. We won't go beyond the guidelines that have been announced, but I think we will be able to produce in due time these guidelines, and we will be also ready internally. You have to realize also that for us, for each national DPAs, to be able to be ready collectively means in most of the cases to have a national law that is voted in our 28 national countries in order to articulate the national procedure with the European bit that is in the GDPR. So it means that 28 national laws have to be voted before May 2018. So it's kind of a complex situation, but I think as far as the Working Party 29 is concerned, we will be in time.